true. One nation, under God, indivisible, with liberty and justice for all.
The review and approval of the minutes are on file, and then hand it over to you for old business.
Okay, I just want to say good morning to everyone. I'm very happy to be filling in for Dr. Cecil, and I appreciate all of the work that you've already done to kind of get us up to date on a lot of the policies. So it's my understanding in old business that we had a couple of policies that were not sent forward in June that are here for a first read. So the first one being student publications. Some of the reasons that didn't go forward were there was some language around the ACLU that needed to be added, and in some case maybe omitted and changed to a different version. So in red, it's in red because I did ask Mr. Penius to kind of refresh my memory, because that kind of took place when Dr. Cecil was here, just to kind of put in the information that needed to be added. And so it's in red in this case. So you can see that 1 and 2 for under the different types of publications stay the same. 3 also was the same, but 4 and on was sort of added in the language there. So incite students as to create a clear and present danger of the commission of an unlawful act, the violation of school's district policy, or the material and substantial disruption of the orderly operation of the institution. Administrations must have a forecast of material and substantial disruption on a specific facts, including past experience in the school and current events influencing student behavior, and not on undifferentiated fear or apprehension.
After Mr. Hennius fixed this, was it sent back to the ACLU?
Not to my knowledge, not saying that it wasn't, but this, I believe the day of the school committee, Dr. Cecil knew exactly what needed to be added,
Yeah.
but I was not aware exactly what they were changing.
Because when I was corresponding with the ACLU,
Yeah.
it's after Mr. Hennius had fixed it the first time, I sent it back and said, "Is this, are we not breaking any laws?" And they basically were like, "No, you still are."
So my guess is that this is the most current because this just came back to me within like the last week.
Okay.
So I can double check for you if that would be
Yeah, because I
something.
feel like if we don't get their approval, we're gonna come back
Yeah,
and trouble
right.
again as well.
Exactly. But I believe he just did it like at the end of last week, so.
For the precautionary, I'll send it to the ACLU, or
Yes, I'm not really sure that's,
I'll go back to the people that I was coordinating, the man and the woman, got their names down, I was coordinating, send this over to them as well.
Okay. Anything else on that?
Just the under number 4, the sentence, administrators must base a forecast of material and substantial disruption. What do you mean by base a forecast of material?
I'm certainly not 100% sure in terms of like what everyone else is thinking as well, but isn't this also talking about how it may disrupt the environment? So maybe potentially thinking ahead that the material would disrupt that environment to the extent that they would have to.
It's just that it doesn't make sense.
Just don't like the word it's worded.
Right? Whoever did that, it doesn't make sense.
Easier language, comfortable for everyone to interpret.
Because there would need to be an adjective in front of material, must be forecast, possibly, whatever material on substantial and on specific, et cetera. So the on specific facts, that part of the sentence makes sense. But the basic forecast of material and substantial and and possible substantial disruption. So must base a forecast that material might be problematic or substantially disruptive or so on. And so whoever wrote this maybe has
Based
that-
on past experience, not on their individual
Right,
fear or
Right.
apprehension based on nothing
So
other
that
than
part
their
of the
own fear.
sentence makes sense.
Yeah.
But this part,
It's
a forecast
It's a
of
little convoluted.
material does not make sense.
Any suggestions? Forecast
It's a lot.
or
Well, it's really must base a forecast that material might be potentially disruptive or substantially disruptive on specific facts.
potentially, you said?
Who wrote this?
Not me. Andrew, I believe it was all in his writing.
We should.
Or if it wasn't Andrew, his office, I sent it back to him. This, everything in red is what he changed. Administrators must base a forecast that potentially what did you say after that, Darlene?
Well, it's
Potentially disrupt.
because the forecast, it's not a there needs to be something in front of material, like what kind of material. Must
Potentially
base
Disruptive?
disruptive, I know,
forecast-
that's kind of where
that material is inappropriate,
Could potentially.
could be inappropriate or disruptive, because you've got the substantial disruption in there already.
controversial or potentially that we.
What
Yeah,
about just take out of material? Darlene, what about just taking it out? Administrators must face a forecast of substantial disruption on
Yeah.
specific tasks. Just take out of material and
Get rid of the rest of that.
then keep everything else.
must base a forecast of substantial disruption.
Yeah, administrators must base a forecast of substantial
Yeah.
disruption on specific facts.
I agree that makes a lot more sense.
We'll find
But my worry is like, why did he put the word material in there? Like, I'm just worried that like there was a purpose behind his, like what does the law specifically speak to in terms, you know what I mean?
Well,
Yeah.
then must base a
But we're gonna
forecast,
ask him, right?
Right.
Okay,
Yeah.
okay.
administrators must base a forecast that material could be substantially disruptive on specific facts.
Is that what we're going with now? Or do you like put it?
That's definitely something that needs to know.
I feel like maybe we just leave what we have right now, if that captures what you're saying, and then ask to see if there was a reason that the
Yeah.
materials
Yeah.
needed to be there before we make all that editing and then find out it's not correct.
Yeah, I mean, if Andrew obviously pulled that specific
Yeah,
wording
that
from
was my-
some sort of
Although
legalese, then keep it.
now that I look at it, material actually could be functioning as an adjective in that sentence. Administrators must face a forecast of material and substantial disruption. So the disruption is material.
Okay.
Okay.
So I guess you could, but I think it could be more clearly written. Clearly. But if that, but based on the context of the rest of the piece, the use of the word material, it
That's
could be that material is being used as an adjective.
That reads right.
Compound adjective with the word substantial
Mhm.
to describe disruption,
Mm.
a material disruption, although, yeah.
Not a disruption because of the materials.
We're going back, but I can ask that question
Yeah.
about material
Yeah, just
being
to
used as an
clarify.
adjective.
Could I diagram it? Yeah, would you like me to diagram it? Good old seventh grade, Wyndham English skills.
All right.
We
Anything
don't
else
do
on
that
this?
anymore.
Down in the last, well, there is a little bit more. He put in, instead of, is inconsistent with, he put in violation of on page 2, but it's, and then in the bottom as well.
Now, are we gonna send this for a first read, or are you gonna send it to Andrew with the questions, bring it back, and then send it for a first read? How are we
It's
gonna
usually
do that?
pre-prompt. I would think that we could potentially have it ready for first read next week.
Well, I'm gonna send it to the ACLU, and I know we won't go forward if they're gonna be like, no.
Right,
So, bring
Right, so what are you asking me to wait to see, or?
Personally, because I think if the ACLU comes back, I don't know if we personally would feel comfortable like passing it through without the ACLU's approval that we're not, you know, doing anything wrong. Say,
That's fine.
because that was the problem with it the first time, because I said, no, it's been, because I, like I said, I personally reached out, I said, no, we fixed it, and they said, no.
Okay. So we'll hold off.
On the second page, at the top of the page, the big paragraph that's underlined, the last sentence there, in such cases, the district reserves the right to edit or delete such student speech. There's a comma, including photographs. Can you put a comma after photographs?
Right here, right?
Yeah.
All right, if there isn't anything else we can move on, especially if we're not gonna send this one right away. All right, so the next policy that was, went back to add language for clarification. My understanding here, and correct me if I'm wrong, was there was conversation around, this one is student fundraising activities and sort of differentiating between school run versus PTO and PTA, I believe, from the
Well, I
last
think it was just
conversation.
also distinguishing what, I mean, according to this, every PTO and PCA already break the policy, so why not just fix it? I mean, so if we only have to do smart snack during school times, why not address the policy of that, saying that exact thing? I was kind of what I was getting at.
And I believe, if I'm not correct, please, but in the second page, B, there is something specific about PTO or booster clubs added here about, with the exception that food and beverages sold outside of the school hours do not need to follow the smart snack guidelines. Is that fit what we were discussing?
Yeah, as long as it said,
I think she was gonna add, Dr. Cecil was gonna add that after your conversation, so that's
so
what
she
I.
already did that.
Yeah.
Are we missing a C in snack?
I was wondering the same thing. I think that's their logo.
Well, if there's a C on the first page.
Oh, there is?
Yeah, under number 3, food
Yeah.
and beverages are subject to the smart snack, but knowing the way brands
Yeah.
market themselves,
You know.
you've got people thinking that LITE is an appropriate spelling of the word light because it's all over packaging.
Do you know smart snack? Smart snack, is that the way they spell snack?
SNAK or SNAC?
It actually, everything on Maryland Department of Education guidance for schools that. Was the, would it
It's,
be under the line?
But they're listing it with a C in it.
So with a C on, under number 3.
Yeah, I see where you're seeing.
it's CK.
I think it's
From the USDA.
I think they could
CK.
It's CK, because also in the policy, it's CK.
It could be in the.
Yeah. All right, so where is the last one? Right here.
Yes, that's requirements.
So I fixed it in B. And then wasn't it somewhere else as well on that page 2 or?
On the first page, but it was spelled correctly.
It was,
Yes.
A guide to smart snacks in school, it has a C.
Okay, all right, so I corrected that on the second page in the PTO section, PTA, booster club. Anything else here? Yes.
Under A, the numbering is off, it goes from 3 to 5.
Thanks.
So all the other numbering that follows will have to get updated.
They're not missing a 4, are they?
I wonder if 4 is in the body of the paragraph.
Yeah, that's
somewhere.
right.
Yeah.
It's good.
So am I redoing that?
I didn't see
Yes.
it.
This was, you know, I didn't change this was what she added, and I never touched it, so, if I'm wrong in changing these numbers, let me know.
When we say outside of the school day, the smart snack guidance, like specifically states that it's supposed to be like an hour after school. So like, I don't know if that's, usually like when you write like your health and wellness policy, that's a thing you put in, and it's even on like the guidance for smart snack compliance, so this is an old version, but I don't know if we want to specify that like it's supposed to be an hour after the conclusion of the school day.
Yeah, if that's the guidance, then put that in there.
Because otherwise we're, selling snacks at 2:25. I don't know if that's problematic or if we don't want to worry about it.
So that appears in B, was it above 2? Wasn't it in
The only thing I'm thinking of is they hold that special event at Robertson every year with the that club, what's it, the Rotary Club.
Yes.
And they provide snacks that I'm not sure if they're with the guidelines. Would that be?
Does that event raise any funds for the school?
Yeah, they
or is it-
selling snacks?
No,
That
they
doesn't
still
apply.
volunteer the
Yeah.
entire, right, the Rotary Club, they don't sell anything, they just give everything, even cotton candy.
Yeah.
Would that be a violation of this
No,
policy?
it's only sale.
Yeah.
Yes, just for sale, but they're not selling.
Yep.
So would be a violation?
During the school
Yeah.
day.
During the school.
Yes. But not-
It's
are you
not
okay
an
for
hour
after?
after, that's the only thing I'm
Yeah.
trying
Oh,
to figure out,
it's
right? It's
not-
not an,
But it's not a fundraising activity.
it's not a fundraising.
Yeah, so
activity.
this,
It's completely donated.
that's fine.
I just don't want it to come forward.
I miss the old days of bake sales at lunchtime.
So are you asking for just in section B to say specifically outside of school hours to mean 1 hour after the school day is over?
So smart snacks,
What we're asking?
on the Department of Ed website, it says, smart snacks in school, the USDA smart snacks, nutrition standards, support better health, blah, blah. Smart snack standards apply when competitive food and beverage items are sold to students on school campus during the school day, which applies to 1 hour after the end of the official school day.
I don't think they sell anything at the elementaries after
No,
school.
they don't.
Nothing.
There's events, but it's usually more than an hour after the
Yeah.
end of school. But do we want to add in that last line, exception that food and beverages sold at a minimum 1 hour outside of school hours do not need to follow? Do we want to add in the 1 hour or just leave it as outside of school hours?
Elementary would be, typically you don't have a lot of activity after school. For you,
But it's.
at middle and high school, you have a lot of activity. But do you typically consider that 1 hour after for department night, well, that's still school hours?
Not it's after school.
You'd say it was after
I'd say
school
so.
hours?
Right, I say it's after school.
Okay.
Yeah, no, I would say 2:25, the bell rings, everything else is after school.
Yeah.
Right.
So can we put or
Just leave it as is then?
Yeah, I would just think.
leave it as?
Leave it
as
is.
Because this is an
Because you know,
exemption
if
to the
somebody,
smart snack.
somebody sells something 50 minutes after school, there's gonna be that one person
Right,
that's
I
gonna
just, personal
complain.
experience, may have gotten in trouble for that once in a prior life.
Oh, really?
Why bring it up? You may have been there for that.
I was.
All right. Anything else on this policy? We're okay to move that forward then?
All right, yeah, just change the numbers.
I finished that, but it will let you. This next one is under our new business. This is the updated version of the final rule for Title IX policy and grievance procedures. It is, this policy is now 18 pages long. It was a boilerplate, so to speak, or a template that we received from the lawyer's office, but also ATIXA, our people that do our Title IX. One of the things that I'm not sure how helpful this is, because for me, jumping in, I kind of had to look at what we had in place before, because they aren't super different, but they're set up differently. So as you read it, you're going to find in the new policy that it's much more explicit with definitions, even the procedure. It's a little bit more specific on timelines. So I don't know if you'd like me to go through some of the places where I saw that, or is it helpful for you to see the old one as well? It just doesn't always match up, but I just want to be transparent that I don't want you to just take my word either. What would be most helpful for you? I have a hard copy of that one, but this one's 11 pages, so it doesn't really quite, jive with the other one. Okay. So as I went through this policy, the first page is set up differently, just kind of talks about more explicitly the statement that Warwick Public Schools has to have on their website and the notice of non-discrimination that has to appear for all different versions. It also, on this page, talks about who our Title IX coordinators are, and we have two in Warwick. We have Mr. McCaffrey and Mrs. Cousineau at the elementary level. So when we get on the second page of 18, the definitions are sort of reworked here. Some are the same, like complainant is somewhat similar, but much more specific. You have 2 lines where they've added a few extra words, like even though we talked about employees in the old version, it actually stay in line 1, a student or employee who is alleged to have been subject to conduct. In the old policy where we get to complaint, they've sort of dropped the word formal complaint from that. So in this case, it almost seemed a little more broad than it was before. Party is a new definition they added. Pregnancy is a new definition that has been part of this Title IX discussion. Relevant is added as well. And I don't want to rush you either, so please tell me if slow down if I. On page 3.
So a complaint
Yeah.
can be an oral request too?
Yes, I believe so. I think from what I've read, it can pretty much just come by any way of, conversation.
Yeah,
Yeah.
In my opinion.
and the Title IX guidelines are changing. August. They were
Yeah.
changed,
That's actually coming up on this 3rd page, but yes, yeah. So that was sort of why we were trying to fit in another meeting. This came to us like July 3rd, and we didn't have a July meeting scheduled, but technically this goes into effect on August 1st. So on page 3, respondent, they added and tweaked that definition. Student with disability is new. So in this, it talks about a student who has a disability and gives that definition. Scope has defined a little more explicitly, where it didn't really tell in the last one, very specific about, what the scope of the work is. But here is where it says August 1st going into effect. And you'll also see for alleged incidents occurring prior to August 1st, the policy and procedures in place at the time of that alleged incident applies. So Mr. Henias has asked us to make sure that we keep the old policy in case we get a complaint that actually is dated prior to August 1st. But moving on, this is the new Title IX. I've added the work page, our website. Jurisdiction is definitely a new called out section. So I'm going to give you a second. I don't think you need me to read it all, but I'm certainly happy to. But again, it was a boilerplate. I plugged in what I needed to plug in there.
And I'm assuming if someone makes an oral request to public schools to investigate, that the Warwick Public Schools has to document that in writing. There has to be a file created. Is that in here somewhere?
Yes.
Okay.
I think this is where I see a lot more detail as we get into page 4 and
Okay.
onward. You get into like the whole grievance procedure and what our timeline, like we have to keep.
Okay.
So if it doesn't address your question, let me go back to that.
Okay.
So on page 4, this prohibited conduct, here's where we get into some newly very explicit information about sex-based discrimination to include, the sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity, which was not called out in the last policy. The same is the case for sex-based harassment. They've also added the quid pro quo harassment section. Again, it's not that they weren't in there before, it's sort of just understood. It was a lot more broad, it seemed. And a hostile environment for harassment.
So it's not underlined in this, the changes.
No, because it was a template. The whole thing, the only thing that I had to change was putting the word public schools in. So I have the original template too. So again, this is sort of a different type of policy to review. So whatever's helpful for you to see, but all I was asked to do was plug in word public schools in some cases. And that's the part where I underlined, and I'll show you on the next page where I had some leeway as well. Yeah.
So just a clarifying question. We really don't have a choice, right? I mean, this
It
was the
doesn't
Title
seem like
IX template.
Mm.
Yeah.
And it went into effect August 1st. We're gonna bring it to the school committee, but it went
There
into
were
effect August
exceptions.
1st.
There were
So
exceptions. Remember I reached out to you, I said a parent had sent me something
Right.
for a group where a whole,
So parts of the country, my understanding is they put an
Yes, they did
injunction in
reach
place,
out.
but it didn't pass in Rhode Island. So
It
that
didn't
is
pass
gonna
in Rhode
move
Island.
forward. Yeah,
Okay.
I did check with
so this
Mr.
is
Hennigan.
essentially a delay.
This
Yeah.
is
Yeah.
it.
Well, that's
I don't
easy.
know
As
the
I'm reviewing
person.
it,
Yeah.
there's really not
I-
much debate here.
Yeah.
I don't know the person, but I did want to honor what she
Yeah.
had
Sure.
sent to me.
Absolutely. And I looked into that a little bit more deeply because I was like, I'm better prepared for that if that's the case. But that's, yeah, and according to Mr. Hennias, that did not go forward. So we are good to go and move this policy forward.
So again, publicly, this is mandated, it's not choice.
Right, right.
This is mandated by RIDE.
This
Or
well,
it's
federal,
federal.
yeah, it's-
And already went into effect.
yes,
6 days
it's
ago.
just more explicit.
Federal, you don't get a choice.
No choice.
If the words aren't allowed.
I know. And it does very nicely.
It has
does.
been.
So on page 5 of 18, again, this is getting into specific offenses. So you might have things in here that you didn't before. Retaliation, for example, I don't believe that was really called out in the last one, the bottom. And then the reporting on page 6, this is, I think, to speak to Tracy, your question about how specific this is. Again, gets into a lot more detail about what steps we have to take, what goes in writing, what notify, parents or students or those that are, have complaints against them. One of the areas that did get added that, well, it's not necessarily added, but it's a definition of confidential employees, I guess. We've always had supportive measures. So supportive measures would be like if somebody needs counseling or anything like that, it's our duty to provide that. But confidential employees, it's spelled out that someone can go without filing the complaint and speak to, like, for example, we've listed HR here confidentially. That person in HR has an obligation to give them the Title IX information, the coordinator's name, but doesn't have to, I believe, if I remember correctly, report it. Sort of just a person that they can talk to kind of get their bearings to go forward.
Can I just make one comment that I noticed here that we put contact the Human Resources Office?
Yeah.
But twice prior, we actually named Bill McCaffrey and named Patty Cousineau. Can we just leave it as Director of Elementary Ed and Director of Secondary Ed in case those positions obviously at some point change? We don't have to come back and redo the policy again, remove the names, just like you did with Human Resources Office.
And that was intentional because of that exact reason.
Yeah,
I
Because
don't,
we'll have to redo the policy every time the position changes.
Yeah. I don't know how everybody feels about that. It was named before, like on our website, a direct person.
Yeah.
So for Mr. McCaffrey was on there, so I don't know how we're feeling, if
Well,
that's too much of a lift for people to have to find out who
It might
it is
be. And you might be accused of,
not being so transparent with that, right?
so therefore, should we put a specific name for the human resources
Yeah, we
office?
should put Kim Ruggieri then.
No, we should put Kim Ruggieri.
Okay.
It's just that knowing that we are gonna have to come
No,
back and
I know.
redo the policy
I
every
would-
time the position changes.
Yeah.
A certificate saying you've received so much training.
So Kim Ruggieri
So all
and
complaints
for
are
Director
subjected
of Human Resources.
to what you guys decide.
Well, we'd have to do that then for each
Right,
of them.
well,
Yes.
yeah.
Yeah, we could do that.
But if any of those names change, it's just, you'd have to come back to the policy.
Yeah,
committee.
I mean, it's a quick change, obviously, but every time it changes, we're gonna have to come back.
Well, then again, we have to change it on the website, so it's gonna be like an automatic, like, oh, we need to go change
Yeah.
that anyway.
Yeah.
All right,
I just wanted
no, I
Point
point
that out.
that was the thinking. All right, supportive measures, that, again, all boilerplate. On the backside, one of the things on page 8, this was what was in there before and what was listed for us as far as supportive measures. But we were and allowed to add to it. So for example, counseling, academic support, extensions of deadlines or other course program related adjustments, restrictions on contact applied to one or more parties, leaves of absence, training and education programs were all part of what we had. And we do have the ability to add to this list if anybody sees anything more that we need. New in this policy was a little bit, I believe, more called out about, again, the timeline. So supportive measures having to happen within 3 days of receiving the request, and provides a written determination to the impacted parties and the Title IX coordinator. Section 9, students with disabilities. This is something that I did not see in the other one, where it says if the student has a disability, the Title IX coordinator must consult with one or more members of the student's IEP or 504 team to determine how to comply with the requirements of the Individuals with Disability Education Act and Section 504 and Rehabilitation Act of 1973 throughout the Warwick Public Schools implementation of its grievance procedures. I don't believe that was spelled out last time like that. Emergency removal administration, all of that was similar, just kind of reworked more explicitly.
Do we need
again,
to add employee in there, or is it only student? Because it says administrative leave on here too, but we don't have employee in the language. Just says student respondent.
I would defer that this is the language, because it was the template, I didn't alter that, so I'm not sure if that should just stay the same. It's certainly a question I could ask if everybody
Because
feels
the
that way,
student
but
responded,
I
it's
think
not gonna get administrative leave, that would be an employee.
right, but in that section, it doesn't say that, right?
No, it doesn't mention employee.
Below it though, it
At the
says
bottom.
employees are subject to
correct.
existing procedures
On the
for
third,
administrative.
like, paragraph.
Yes.
Oh, all right. Oh, okay, thanks. Sorry, didn't flip the page.
All right, speaking of flipping the page then, page 19. Again, in that second to last paragraph at the top in that section 10, this is the disability with Title IX coordinator would consult with one or more members if their team is added again. Emergency removal process remains the rights granted by the Individuals with Disability Act in section 504 and the Americans with Disability Act. So grievance procedures and complaints for sex discrimination, all this kind of was all mapped out. The one thing that I would just say looks different or seems different was more of the timeframes. As we reviewed it with Mrs. Kuzno and Mr. McCaffrey, I think we were really trying to picture what that time frame looked like. Because the other one, although it had a time frame, it might have said like within 120 days, this will be wrapped up, but not very explicit about 10 days here, 3 days here. So I think that's where I see some major difference in the way that they've been explicit with that. Page 10, again, the complaints expanded, more detailed. Initial evaluation, the adding of timelines within 7 days or things like that. On page 11, notice of allegations, more spelled out about that as well. Again, didn't note any changes really, just more detail. On page 12, the only thing that I made note of was new language around impartiality. There was certainly language in the last one about bias and conflict of interest, but not as detailed. And as we move through the rest of the policy, really this was not anything that was, other than putting Warwick Public Schools in there, there wasn't any language that we had options of changing. So I know, I'm kind of going through it thoroughly, but, or as thorough as possible right now, but I don't even really have major notes here, just it really, when I compared the two, same stuff, just more detailed. So the rest of the pages, it's to page 18, you have very similar. I'll just let you look through that. About the standard of proof, written notice of determination, disciplinary sanctions, and so forth. I will point on page 16, appeals, that appeal decision maker language, we did talk about that in our meeting. but we were advised by Mr. Henius to leave it as appeal decision maker and not box us into third party like we were thinking. And then again with a timeline. All right. Anybody have anything you would like to add, or not add, but comments?
So there's a gentleman all over, I think he's gonna be talking. I can't go to the school committee. He said that there was an option for us to make our own. You said these words were mandated. So is that information wrong? That's gonna.
It may just be in the way that, I think because we receive, it's a federal law, but I would say that we are obligated to follow. We always have. I think if the conversation we had before about this particular Title IX, this language was being held up by some states because of the language around the different definitions of gender and gender identity. But as far as I know, it's not really a choice that we move forward as a state that this is what we do. But I don't know if I'm understanding your question completely too, Michelle.
Because I didn't get a chance to look into it, so I don't really
Okay.
know. I mean, you guys might hear about it. We
Yeah.
probably hear about it.
Okay.
I'll watch my dad's. But I guess the elephant in the room is, so this is obviously here to protect a certain group that needs protection, but then there's the parent side of the fair side. Do we have any other systems in place to address the fair side? Does that make sense? But like bathroom use or the school sports, I don't know, all this is coming up from like this Title IX.
Okay.
So, like I said, this is to protect certain innocents, which should be protected. But then there's the other side, the parents are freaking out on the other side. Do we as admins have any other way to address the other concerns?
What's the other side? I'm confused as to what
The
the
bathroom
other
issue.
side is.
Yeah.
Because, I mean, even that is like, I have a daughter, but I also have family members that have transitioned, so I see both sides. So there's kind of like two sides to protect as well, if that makes sense.
Yeah.
So the bathroom issue, some people it's not to bring up sports, so on and so forth. So I guess as an administration, where is the line in the sand, you're saying?
Yeah.
Protecting both innocent sides. There's innocence on both sides.
I think the detailed process and procedure that's in here, and with the different levels of investigation that has to go on in the appeals process, I think if somebody makes an unwarranted complaint, there should be enough in here to kind of catch that, like even the initial investigation within the 7 days when Bill or Patty sits down with the person making the complaint, they might even be able to see right off the bat it's not justified. But yes, because people get accused wrongly all the time. And we have innocent until proven guilty in this country, except that's not always the case. And people who are later found innocent, nobody sees that. They only see the initial headlines. So I think this is so detailed that at some point, if someone is wrongly accused, it should come out, it might even come out within 7 days, but I can understand where there's a concern.
Yeah, I think the detail in this, I think, kind of protects everybody. I think it's kind of drawn up to sort of protect everyone.
Yeah.
Because it's so detailed.
There
I mean,
are
I
a
get
lot
it.
of, there are, it's what, 19 pages long, there are a lot of.
It's protective measures for both parties.
Yeah.
Then, if someone makes a complaint, that other respondent won't automatically get punished until it's investigated, and then that each get protective measures.
There'll be interviews and witnesses and
It's pretty extensive in terms of, I know, when Bill or Patty have had to do this, it's very time consuming, extremely extensive. And, so I would say that no one is, they're following everything and making sure they have the proper evidence as well as, notifying different parties and whatnot, but.
I do feel like in the schools too, and I know I'm in elementary, but even in the middle school and the high school, I feel like administration and teachers kind of go out of their way to make sure that every kid feels comfortable wherever they are. If there's like a bathroom issue, then we set something up so somebody can have the privacy of.
I
So
think that's like gonna be the hardest thing for administration in this situation.
Well, it is, but I feel like everybody addresses it. And I know they do in our school. I feel like everybody's making an extra effort to make sure that everybody feels comfortable.
because there's always the bathroom in the nurses area.
Correct. There's always those isolated, there's a handicap bathroom that, is one stall, whatever, that like sometimes when kids are not comfortable, even just going with other students in like a larger bathroom, whatever, at the elementary school level. Like we make accommodations for all of that. It's not a big, like, we have to write it all up. Everybody just helps that student feel comfortable. You know what I mean? I do feel like everybody's trying to make an extra effort to do that. And if parents have concerns to, talk to the administration in the school. And I feel like everybody's on board with making everybody feel comfortable, no matter what side of the, your views are on. It doesn't matter. I feel like we're all out there to make kids feel okay, no matter what, so.
And as far as locker rooms, do we have curtains now on all our locker room stalls? Because we had an issue, or I know we've had issues in the past, our secondary locker rooms, do they all have curtains now on the stall? I mean, nobody takes showers anymore.
Hope
you know.
so.
I mean, the showers don't even, toilet showers, they never worked, they never been gross, so you never know.
That's just a lawsuit right now.
But there was a time when only a handful of stalls, like changing stalls, had curtains. So, I mean, if that's something that needs to be taken care of, that needs to be taken care of.
All right, we can move on to the next one, if that's okay. There's one last one. This one, I don't believe you've seen it all as well. And this is the building and ground safety and security. And that wasn't reviewed that long ago, I believe.
Just a few months.
Yeah.
Recent.
And so so you did see it not that long ago, but I believe the new language was to add in our RAVE app. And so in our first paragraph, it talks about the use of emergency communication system. And then towards the bottom, added language around the use of the panic button mobile application. So those two things were added to reflect our RAVE app. Any questions or thoughts around this? Okay, all right, so just to recap, we are gonna hold off on the student publications, but we're gonna send forward the student fundraising activities, the final rule, Title IX, and the building and ground safety security. And then review policies in August on our agenda. I believe these are all the ones now, believe this is true, but these are all of the policies that were looked at and not maybe changed, just up for review. I believe that's how Anne kind of did that. So, any public comment or anything like that? How about the cadence of meetings, the Tuesday, first Tuesday of the month still works for everybody, keeping it the same?
I would prefer to change it, but to maybe the first Monday of the month.
I have a conflict. Well, first Monday actually works for me. Third Monday I have a conflict, so that works for me. Sorry, I have juvenile hearing board.
How about you? Yeah, I know you're scheduling something at night. And then the 4:30 works fine for everybody? Okay, so if it's okay, then we could move it to the first Monday of the month?
I thought she did a survey.
Did she didn't tell me this.
I thought she did a survey to see who was it.
Yeah, but we're all sitting here now, if it's okay to change
Yeah.
it. Tuesday did not work for me and I had to move things around. But if
Yeah.
Tuesday is better, I will.
First Monday works. I just have I have juvenile hearing board with the city, but, that's usually the third Monday, so.
Mondays are easier, Michelle.
Yeah.
Oh, wait a minute.
Problems with Mondays though are holidays.
Yeah.
A lot of holidays on Monday.
Yeah,
Yeah,
Good point.
it was an issue.
Wednesday?
No, Wednesday's out. I have way too many.
Wednesday's no good, Thursday's no good, and that's Thursday.
Friday?
Monday,
No.
no.
I'm by myself.
Mondays are generally tough for me.
Yeah, and I think
I'm
Monday
not the
can be
deal.
tough with the holiday, but
Yeah, I'm just,
we didn't look at that. So it sounds like we might keep it on Tuesday.
yes, September and October, that knocks the Mondays out right there, I think.
Is that okay? It doesn't have to be, well, Tuesdays in general are rough. You're saying it doesn't have to be the first
Is there a better
Tuesday, it could be
time
the
for you
third.
Tuesdays, or is there a better time for you,
Yeah.
or? No, on
Well-
Tuesdays.
Earlier, but that doesn't work for everybody.
Yeah, I don't get out till 3:30,
Yeah.
but we could do 3:30, well, 3:45.
No, because I work.
Yeah.
Oh, okay,
Yeah.
that's,
No,
yeah.
keep it 4:30 on Tuesdays.
4:30 on Tuesdays. Okay,
Sorry,
so we
darling.
will do that. I did receive a new policy that the finance bidding wants us to review for September, so I think that would be it. Oh, well, we do have other things that were on the docket as well. I know Anne was like a machine trying to go up, and so she has a list of things, but so we'll add a few at a time. I don't know that we'll do as many as she was able to do, but we'll do a few at a time. Yes.
September 3rd, 4:30,
Is that our first Tuesday?
yes.
All right, September 3rd at 4:30.
Is that the day after Labor Day?
It is.
So they're like-
Thank you for the donuts.
All right, so I will send out that invitation.
Motion to adjourn.
Second.
I'm putting it on the calendar.
As soon as I said, I was like,
Meeting is adjourned.
Yep.